SJC-12796, Montanez v. Nancy Flahive.
Mr. Schubert, good morning.
Good morning, Your Honor. If it please the court, I'm here to argue today that if we can note that most recently it has been argued in the halls of government that facts and law actually do matter. We say that obviously that's applicable to this particular case. It's important to note in this case that we believe that a primary count of the complaint has been thrown out of the complaint, and that Brown versus Gerstein is actually the law that's applicable to the count of unfair and deceptive business practice. It's important to note for the court that this was a case where that Ivelisse Montanez, who's in the courtroom today, in 2007 went to a lawyer. She sought legal advice and the filing of a suit. That lawyer did nothing. That lawyer actually even prepared forged documents with court numbers on it and gave it to Ms. Montanez in furtherance of her subterfuge of doing nothing in this particular complaint. She took money and did nothing until such time as that a statute of limitations was in question, and then they filed suit. But eventually the entire situation was dismissed based on a failure to even make service, appropriate service, on the defendants in this action. So when this case comes to me and I file a malpractice action against that lawyer, we are faced with the interesting fact that that lawyer has already gone before the Board of Bar Overseers. She was represented by my brother here. And at that hearing, as you have in the record, she signs an affidavit and she admits to the crimes that she has committed. And they are crimes too, criminal crimes, not just unethical conduct. They are actual criminal crimes. In the preparation by the plaintiff of its case, it tries to establish that there's been a pattern of conduct here. And the pattern of conduct is absolutely clear. We discovered that not only had she abused Ivelisse Montanez, but another client that she took monies in the sum of $6,000. And she used that for her own personal use. And then eventually when she came before the Board of Bar Overseers, it was just before that that she submitted a group of checks to pay back that $6,000 on the personal account of her husband and herself. Her husband, also a lawyer in the Commonwealth of Massachusetts, a partner at a firm in Boston with a satellite firm in Springfield.
Can I ask, what did the appeals court do in your case?
The appeals court with Justice Englander just said that there was no reason to proceed in this matter whatsoever. And that he really didn't address it at all, to the best of my particular knowledge.
And could you have appealed his decision to the full appeals court?
I did not, because I don't believe that you have that as a matter of right, sir.
Could you have done it?
No, I do not believe so, sir.
But you had no other avenue of relief except for the single justice of the SJC. You couldn't appeal Justice Englander's order to the appeals court?
Yes, that is my position, sir.
Well, I know. What is your authority for that position?
The fact that you cannot appeal the single justice to a panel in the appeals court. That's
because it was interlocutory.
right.
Right.
So my position is that there was, let me just say this, that there have been obviously 6 judges in this particular matter that have ruled. When we look at what we have here, and I don't think that there can be any argument that in Brown versus Gerstein, where they say that deceit is a necessary thing and it becomes a matter that will prove damages. And in this case, there was no reason to send a 93A letter. They were well aware because they had already admitted to the negligence that they had committed. My brother did a brilliant job. She received only an 8-year suspension. And then, relative to the $6,000, you do have to ask, in the interest of justice, the Board of Bar Overseers and the Client Security Board paid $6,000 to the client that was actually aggrieved and who had no legal work done for him whatsoever. As in this case, The facts are frightening, and they were well aware of the facts that are frightening in this particular case. Just briefly to address that I've even lost the ability to take the deposition of the husband, a lawyer in the Commonwealth of Massachusetts. I think that the plaintiff is entitled to know who knew what and when. And furthermore, it certainly seems that his status is undeniably that of an unindicted co-conspirator felon. And yet, no one seems to even, they said that there was nothing that could be developed by a deposition of this person. And if he exercises his right to either marital privilege or taking the Fifth Amendment, it would certainly seem that that would be admissible at trial.
Now, the question, I gather, is why should this not wait until the final adjudication? You know that we sharply limit the ability to do interlocutory appeals, which is why you have no appeal within the appeals court for Justice Englander. So since there's no right to appeal to the appeals court, why should you have a right to appeal to this court?
And I believe that I addressed that in my pleadings, which is, it shouldn't be that Ivelisse Montanez should have to wait until 2020 to get a final verdict and a reward or damages in this particular action. If we have a trial and we do not get to proceed under 93A, and we get a judgment and we appeal the judgment, which would be her right, the answer is by the time we did the appellate process all over again, we'd be very lucky to make it to 2022. And this started in 2007, Your Honor. At some point in time, I believe the justice demands that at some point in time, we have to get it right on the first go-around. And that's why we're here today. I would also say, Your Honor, that I have yet to see that the respondent in this matter has written anything that denies any of the facts that I've put forth. And the facts themselves are completely, well, they are disparaging at the very least. The judgment that they have on this count was achieved with a material misrepresentation of fact. My brother hasn't argued that that isn't true. And then when they filed their pleadings, they ended up secreting that information on, I think, page 3 of their responsive pleading relative to this. I asked for an evidentiary hearing to establish what the facts were relative to the misrepresentation, and I was denied that also. I must not be a very good lawyer. I'm certainly not liked very well. And lastly, if I can address the fact of the Grassi matter. Grassi, to myself and my colleagues, was a breath of fresh air. It would certainly seem axiomatic that you can't have justice if there is no appellate review. And if there's appellate review, it has to be based on knowing what the lower court actually did. And when you look at the documents in the appendix here, it's incapable of deciding how they reached any decisions that they made in the lower courts on these particular matters. But what's absolutely clear is that they are in contravention of the well-established law of Brown versus Gerstein that should apply to this case. And that therefore, this woman should not have to wait until 2022 when you can clearly set this matter straight. All you need to do is apply the words that are actually on the outside wall of this courtroom, and it would seem that she would then obtain fairness and justice in this particular case and be able to proceed and get it over with before 2022. I just remind you that she has done absolutely nothing wrong, and I know it's rather strange to have me here who is normally arguing in a capital case for a capital defendant. But in this matter, she should not be penalized, and I agree that we do not often give interlocutory opinions that reverse until the final trial, but this is an exceptional circumstance, and there's no way that she should be forced into this situation. Thank you.
Dwight.
please the court, Your Honor, at the full bench. We have not submitted a brief. This is an appeal taken under Rule 2.21 of the Supreme Judicial Court, but I'm happy to answer any questions if the panel would ask for any clarity in the arguments of my brother or in the underlying rulings of the numerous judges who have heard these numerous appeals.
Could you remind me what happened in the Superior Court here?
I'd be happy to, Your Honor.
What's the ruling from the Superior Court?
So it is somewhat complicated. There were 3 motions to dismiss that we filed. The first was to dismiss all counts. The second was to dismiss the fraud count and the 93A count. So on the second motion to dismiss, the court gave permission to my brother to amend his pleading from a Section 11 claim to a Section 9 claim. And when he refiled his second amended complaint, he continued to push forward the Section 11 claim rather than the Section 9 claim. And at that point in time, we filed our third motion to dismiss, which is the motion which was granted. And that was, I think,
And so what part of the case is dismissed and what part is still in existence?
the only thing that's dismissed is the 93A claim, Your Honor. The negligence claim and the fraud claim continue to exist. There's also a breach of contract claim. So there are 3 remaining claims to be heard by the underlying court.
Okay.
So if you were to lose at trial, and then he would on appeal say the court erred and denied the 93A, then arguably it could be remanded based on the facts that were found at the first trial.
Quite possibly, Your Honor. I think looking at the 93A claim, there are multiple citations to the Brown case, but the Brown case only talks about trade and commerce. This is clearly an individual who has entered into an agreement with a lawyer. I've handled many of those cases throughout my career, and they're all Section 9 claims. For whatever reason, counsel refused to amend the complaint properly to ensure that his client's rights were protected with a Section 9 claim. So now it's a Section 11 claim, and the court gave him more than 2 bites at the apple to modify the pleadings correctly, and he failed to do that.
Okay, thank you.
Thank you.